what they have done is adopted so-called all-comers policies, so that a political group, college Democrats or college Republicans, would be prohibited by campus policies from restricting membership to Democrats or Republicans, or a Christian group or a Jewish group would be required to elect atheists or somebody with different faith as leaders in order to comply with the university's policies. I've got to demonstrate two policies that are diametrically opposed. One policy adopted by one college in Virginia requires that membership in organizations on campus be open to all students and that will not be restricted on the basis of age, ability, ethnicity, gender, national origin, race, color, religion, national origin, veteran status, or political
no right of trade association?
None.
None.
On the other hand, College William & Mary adopted this policy, which I say is, I submit, is entirely consistent with federal law and consistent with this bill. Officially recognized organizations, including those affiliated with so on and so forth, shall be open on a non-discriminatory basis without regard to religion, creed, national origin, gender, or political belief, provided, however, that to the extent permitted by law, membership in social organizations may be restricted to members of the same gender, and memberships in organizations whose primary purpose is political or religious may be restricted to those members of the college community who have similar beliefs. This is consistent with First Amendment freedom of association. And what I've shown is that we have campuses across Virginia who have just have different understanding of what the law provides and permits. What we are seeking to do is simply adopt this statement that says to the extent permitted by law. It will not permit invidious discrimination. It will not permit discrimination on impermissible grounds. And that it simply allows the freedom of association that the First Amendment to the United States Constitution was intended to provide.
Anyone care to speak in support?
Mr. Chairman, members of the committee, Chris Friend, representing Family Foundation Virginia Catholic Conference and the Virginia Assembly of Independent Baptists. Today I'm theologically conflicted, but we all three groups strongly support the bill for all the reasons Senator Obuchi.
Anyone else care to speak in support?
Cameron O'Brien with the Attorney General's Office. The Attorney General is first.
Anyone care to speak in opposition?
Mr. Chairman, members of the committee, there was a case decided in 2010 by the United States Supreme Court that this seeks to overturn. The case was Christian Legal Society chapter of the University of California, Hastings College of Law versus Martinez. And in that case, the Supreme Court decided that public universities and colleges are not required to fund and recognize organizations that are discriminatory in their conduct, regardless of the beliefs that inform that conduct. This proposal seeks to turn that holding on its head, requiring all of our public universities to fund all political and religious groups regardless of their discriminatory conduct. The proponents are not asking to be free to espouse their beliefs or to associate. They are asking to be formally recognized and funded to engage in discriminatory conduct that excludes people based on their religion or because they're gay, lesbian, bisexual, or transgender, as one example. Among other things, this mandate violates the constitutional protection of the academic freedom of these public universities, who have that freedom, according to the Supreme Court, to define both their curriculum and their extracurriculum. Justice Stevens, in his concurrence in Hastings, said the following: on many levels, a university administrator has a greater interest in the content of student activities than the police chief would have in the content of a soapbox oration. In this case, speaking of the Christian Legal Society, the petitioner excludes students who will not sign its statement of faith or who engage in unrepentant homosexual conduct. The expressive association argument it presses, however, is hardly limited to these facts. Other groups may exclude or mistreat Jews, blacks, and women, or those who do not share their contempt for Jews, blacks, and women. A free society must tolerate such groups. It need not subsidize them, give them its official imprimatur, or grant them equal access to public school facilities. In this circumstance, to the extent permitted by law, there is a federal law that says, under Title IX, that there's an exception that universities and colleges can allow social organizations, that's quoted in the William and Mary policy, that are gender limited. And that is a specific Wagner amendment to Title IX that was passed that authorized those sex segregated social organizations. There is no law that excludes the possibility of discrimination based on sexual orientation, and it's our submission that the proponents seek to do exactly that, and that you are putting the universities in the position of underwriting and recognizing and giving their approval of authority to discriminatory conduct. Do they need to let these organizations be on campus? Absolutely. Do they need to let these organizations have equal access to their facilities just like anybody else? Absolutely. Should they be compelled by state law in violation of their curricular decisions, as the Board of Governance might determine, to fund and recognize those organizations regardless of the discriminatory conduct? No, they do not need to, and we would urge you to reject this bill as amended.
Thank you very much.
Senator Ovensand, would you care to wrap up?
I just am astonished. I'm thunderstruck at the ACLU, and I guess I should never be thunderstruck by what will emanate from the ACLU, and to ascribe motives to me in advancing this bill, I find it despicable. This bill is limited. It clearly provides that it is not intended to and will not have the effect of overturning any state or federal law, and to the extent that any action sought to, any action by any student organization that is discriminatory in a manner that's inconsistent with the ruling of the United States Supreme Court, this does not change that. This does not permit the type of invidious discrimination that the ACLU is suggesting is the motive of those advancing this legislation. It simply does not. What I've demonstrated is that there is a clear misunderstanding. And we have colleges in Virginia that have policies that...
The matter is before us, and ready for...
Move to report.
It's been moved and seconded, the bill be reported. Clerk, call the roll. You good? Okay. Clerk, call the roll. 10-7.
Senator Sasslaw?
No.
Senator Lucas?
No.
Senator Howell?
No.
Senator Newman? Senator Levin? Senator Locke?
No.
Senator Barker?
Aye.
Senator Northam?
No.
Senator Miller?
No.
Senator Smith?
Aye.
Senator McWhorter?
Yes.
Senator Black?
Aye.
Senator Carrico?
Aye.
Senator Garrett?
Aye by proxy.
Senator Martin?
Aye. The bill is reported 8-7 as amended.
9-6.
9-6. I thought it had 30. 9-6.
Thank you very much.
Thank you very much.